Good
Um,
morning.
are we
No
ready?
obstacles on the way home to Los Alamos. So I'm sorry to hear the uh, the other stories. Um, let's see. My name is Felicia Orth, hearing officer appointed to conduct a hearing in the CRRUA matter and UWB 2413. We're on the platform this morning for day 4 of the hearing. When we broke minutes before 5 p.m. last night, Ms. Carey had finished her direct examination of Mr. Crosby. We turn now to the Environment Department Council to ask their questions. Are there any preliminary matters we should address before we begin again with Mr. Crosby?
I had one,
Mr. Crosby?
Madam. I had one,
Yeah.
Madam Hearing Officer. I just wanted to apologize to you, the hearing officer, and also to the NMED Council. I apologize for yesterday's outburst during the meeting. It was unprofessional of me, and I just wanted to make sure that I apologize. I've been going through this utility system for 2 years, and it weighs heavy on my heart, and I let the emotions get the best of me. So I wanted to just reach out to apologize to both of y'all.
All right. Thank you for that, Mr. Crosby. Are there
I'd like
other
to,
preliminary?
well, two things, Madam Hearing Officer. Ms. Crosby, it's okay. That's what happens in litigation, and I was just as complicit in that as you were, and I hope we can keep it calm today, but you never know. Let's just do our best. We're both just doing our jobs. So I apologize as well. The second thing I had, Madam Hearing Officer, is are we going to be allowed to do a closing today?
My preference as to closing is for you to put it in writing after you've received the transcript and reflected on the evidence that actually came in. That's my preference, and you would have 30 days to submit that in writing along with any proposed findings of fact and conclusions of law. That's my
Okay.
preference.
All right. Thank you, Madam Hearing Officer. That was just a quick question.
Yes.
All right. Susan, are you ready to begin?
I am ready. Thank you.
Okay, and so it's going to be even more of a challenge for our dear court reporter to take down our words on this platform. I've seen, heard a fair amount of folks talking over each other, including me, and I'm going to ask you to try to restrain yourselves a little better with that. And do not talk over the end of someone else's sentence, even if that's an amicable dialogue, and don't talk over me or anyone else, even if it's not amicable, please. We're trying to capture everything in the transcript. Also, I try to remind myself to mute myself unless I'm speaking, and if that's fairly easy for you to do, I'll encourage you to do that as well. So with all of that, please, let's see, I guess it's Mr. Rayel. Do you have questions of Mr. Crosby?
Yes, good morning. Thank you, Madam Hearing Officer. Mr. Crosby, can you hear me okay?
Yes, sir. I can hear you loud and clear, Marcus. And just to let you know, Marcus, I am writing notes, but it's my notes that I am writing down just so I know, because I'm going to be looking, my eye level will be looking down.
All right, thank you. Mr. Crosby, you became the executive director in May of 2024. You testified yesterday. Is that correct?
Yes, sir.
And you had also testified that you started with CRRUA in September of 2022.
Yes, sir.
Okay, so at the time the violations described in the 2024 Administrative Compliance Order occurred, you had been with CRRUA for about 2 years? Or close to 2 years, I should say?
May to May would be 1 year, and then from May to November is what? June, July, August, September, November, about a year and 5 months, I guess.
Okay, so about a year and a half. Okay, thank you. Your job duties as assistant executive director included supporting the executive director. Is that correct?
That is correct.
And in supporting the executive director, you were at times required to step into his shoes when he was unavailable.
If you can repeat that question again, Marcus.
In supporting the executive director, you were at times required to step into his shoes when he was unavailable. Is that correct?
Yes, that is correct. But being that I had little knowledge of operations, that role was split between, at that time, the lead operations manager who would oversee operations if there was any questions. If it was dealing with administrative functions or functions with planning and zoning, functions with meters, functions with grants, that was my specialty.
Right. I heard you testify about that yesterday. But in your role as assistant executive director for CRRUA, did you receive training about the regulations that apply to a public water system such as CRRUA?
I believe I had gone to a water and wastewater training a little bit right before, but no, prior to that, I had received no training for regulations regarding water and wastewater, and specifically when it dealt with compliance matters on MCL levels and such matters dealing with arsenic.
Okay. But I'm sure you familiarized yourself with the water system when you took on your role. Is that correct?
Yes, but not in detail of regulations and compliance. You have to remember there was only 5 people that were working, or 6 people. Out of those 6, we had 3 clerks in the front, we had 1 office manager, and we had the executive director and myself. Being that we were behind on grants, being that we were 1,500 meters out of 7,500 meters approximately down, we were bleeding money. So my main objective and priority was to begin to learn the billing system, which does take time. It's not overnight. Every type of billing system is different. On top of that, the communication between the billing system and the back end of the meter system, which nobody, not even the internal staff, had training. So that was a heavy lift, and that's where my emphasis was.
Understood. I heard you testify about all that yesterday. But let me ask it this way. You understood that you had to provide as a water system clean and safe water free from inorganic, from unsafe levels of inorganic substances or organic substances. Isn't that correct?
I don't understand the substance of your question. If you can please repeat.
You understood that a water system has an obligation to deliver clean, safe drinking water to its consumers, correct?
Yes, that is the mission of every utility system, to meet safe water drinking standards.
Right. And so in your role as assistant executive director, just to be clear, you didn't familiarize yourself with what compliance with the drinking water regulations meant at all?
I don't believe that is a fair statement, Marcus. You cut out, I'm sorry.
Did you, as assistant executive director of the water system, is it your testimony that you didn't familiarize yourself with what it means for a water system to be in compliance as far as safe drinking water? Is that a fair statement?
No, that is not a fair statement. If I'm able to explain, I can explain.
Please, go ahead.
Yes. Being that my objective when I came on to the utility, as I stated at yesterday's hearing, I testified my main objectives as the assistant executive director was to assist with the pain points that the utility was having. We serve over 20,000 residents, and we were already receiving and behind on appropriate procurement for the granting. In this case, the arsenic treatment plant grant clean water, drinking water SRF 5440, over $5 million, and that had to be processed promptly because we were already behind and getting started on it. So my main objectives were to assist. Yes, also the assistant executive director, as you stated, is also responsible. However, it does take time. Anybody coming into a utility system, that was not my background. However, if my background had been with the knowledge that I have and carry and possess today, yes, it would be my responsibility to immediately notify the local compliance office. But at the time that I had that experience, no, I did not have the knowledge of compliance and regulation, nor the levels at that time, because of the duties that I was serving.
Okay, thank you. So on December 1st, in your role as Assistant Executive Director, you were present at NMED's investigation of the pH issue. Is that correct?
Yes, sir, correct.
Okay. That was an operational duty, correct?
That was an operational duty where I had been newly thrusted in there, barely by even having a week as interim executive, barely having 1 week as an interim executive director.
Okay, same question about the December 5th and 6th sanitary survey. You were present at that in your role as Assistant Executive Director, correct?
Correct.
So then it would be fair to say that you, as you said, were forced into participating in operational matters um, um, as the Assistant Executive Director, correct?
I would take back my comment and saying forced, but I answered the call.
And your testimony was that you became the interim executive director on December 8th of that year of 2023, correct?
That sounds about right. December 8th.
Okay, so in your role as Assistant Executive Director, you were able to report issues to the New Mexico Environment Department, correct?
Yes, that is correct.
In fact, it was you that reported the pH level issue to NMED on December 1st, 2023, correct?
That is correct.
And the integrity of a water supply may be endangered if there are high pH levels in the water. Isn't that correct?
That is, but being the experience that I had at that time, I was still beginning to quickly, in my administrative capacity and my research capacity, begin to study the effects of what high pH would be. And that's part of being an administrator, be able to research at that time. So it was quickly accelerated and quickly thrusted at that time. But to answer your question, correct.
And you testified yesterday that you discovered the system had high pH levels on November 28th of 2023. Isn't that right?
Correct.
But you didn't notify NMED of the high pH levels until December 1st, 2023, correct?
Yes, that is correct, but I have an explanation if you would like to hear.
No, I just wanted to establish that fact. No one else from CRRUA notified the public or NMED of the high pH levels until December 1st, 2023. Isn't that correct?
That question cannot be answered with a correct or not correct question. I would need to explain.
Please do so.
Okay. If you could please repeat the question one more time.
Did you or anyone else at CRRUA notify the public or NMED about the high pH levels before December 1st, 2023?
Sorry about that. I'm just taking down some notes, Marcus. So yes, when I discovered that the immediate action that I took was to notify the executive director at that time, who was Mr. Brent Westmoreland. The second action that I took, I'm sorry, let me go back. The first action that I took is I took in the inquiries, and I believe there was multiple calls at that time. The immediate action that I took was to notify the operations lead, because we did not have a operations manager at that time. So I notified the lead operator at that time, Mr. Carranza, and I notified him about the complaints that were coming in regarding the slimy water. And he had notified me that it was due to food grade based oil being utilized at a startup. And I notified the executive director. And at that point, being that I had little experience in terms of operations, compliance, regulation matters, during that point, I handed it over to the executive director, which is the appropriate action of that time to be taking place. The reason that public notification was not sent out is, as you can tell in the 2023 sanitary survey, it was noted that staff and administrative staff have little knowledge regarding compliance and regulations. But since then, I believe that I have shown where I've taken courses regarding through NMED regarding notifications. I'm sorry, RCAC. I've taken courses through RCAC in terms of appropriate notification for the public when it comes to drinking water violations. In addition to that, I've taken courses with the water and drinking water in terms of appropriate notifications. And thirdly, I've continued collaboration with the NMED local compliance office to get a greater understanding of the different types of violations and the requirements that a utility system must have when it is having to explain to the public regarding notifications.
Okay. NMED issued a notice of violation to CRRUA on December 12th, 2023 for the failure to notify consumers of the pH levels which endangered the supply of the water that was distributed to those consumers. Is that correct?
Yes, NMED did issue a notice of violation.
If consumers aren't notified of an issue which may endanger the water supply, consumers cannot take any action to mitigate or protect themselves from that danger, correct?
I believe that you're mistaking the situation as the events took place, Mr. Marcus. The public was notified.
I mean, it's a yes or no question on this one, Mr. Crosby. If consumers aren't notified that there's something wrong with the drinking water, they can't take any steps to protect themselves. Would you agree with that? Yes or no?
Mr. Marcus, your statement is wrong, so I cannot answer that question.
It's not a statement, it's a question. If
Well,
consumers
your question is framed wrong in an event that took place. I can't answer it.
Yeah, I'm not asking you about a specific event. This is just a question. If consumers are not notified that there's something unsafe about the drinking water in any situation, then they're not able to take any action to protect themselves from that danger. Would you agree with that?
Your question changed from the first question to the second question. I agree with your second statement. I don't agree with your frame of question on the first.
Okay, but as to my second question, you agree with me?
Excluding the pH incident, yes, because your first question stated the pH incident of a failure to notify the public, and in the second question, you did not use that frame of word. So I'm agreeing that it is the utility's responsibility to notify the public based on standards that are set by the Safe Water Drinking Act and our New Mexico Environmental Department.
And as you just testified, you did receive a notice of violation for failure to notify the public, correct?
Yes, but we also notified them as soon as that. As I told you, I was still new into the administration.
I got it. Thank you. After you reported the pH level issues to NMED on December 1st, an inspection by NMED occurred on Saturday, December 2nd, correct?
If you can repeat that, Marcus, on the first, because you're putting in dates there, and I have to get a better understanding of your statement.
after you reported the pH level issues to NMED on December 1st, an inspection by NMED occurred on Saturday, December 2nd, correct?
No, I don't think the inspection came in on Saturday.
If I represent to you that it did happen on Saturday, December 2nd, 2023, do you have any reason to disbelieve me?
Yes, I have reason to disbelieve because I think it was a work week that they came in to do the inspection. And I can't
Okay,
recall.
I'm gonna put an exhibit up on the screen. Can you see that exhibit?
Let
It's
me see.
it's NMED's exhibit number 10. Do you see that on the bottom right-hand corner, exhibit 10?
I'm just going to make it bigger so we can see it better.
Let me see here. What sentence, if you can read it out to me, Marcus? I'm having trouble.
Do you see the little, go down, please. Do you see the little black box that says exhibit 10 in the corner?
I see exhibit 10, yes, sir.
Okay, so this is NMED's exhibit 10. And would you please read the first sentence of that exhibit to me?
Okay, I do agree now. I'm getting confused between the NMED sanitary survey and the actual inspection. So you are correct. This is the time when Mr. Joe Savage and Antonio Romero and we met them at the industrial ATF. So yes, I do remember this.
And Martin Torres was there as well, correct?
Yes.
Okay, thank you. So, and I'll get to the sanitary survey in a second. In fact, I wanted to clarify something from your testimony yesterday. You agree with me that the pH investigation and the sanitary survey didn't take place on the same dates, correct? The pH investigation was December 2nd, which we just established. And the sanitary survey, which was already previously scheduled, took place on December 5th and 6th, correct?
No, that is incorrect. The pH incident did not take place in December 2nd. The pH incident took place when the phone calls were first coming in.
I'm sorry,
late,
I meant to say pH investigation. I'm sorry, Mr. Crosby. The pH investigation, as we just established, took place on December 2nd, correct?
yes, the pH incident took place. I'm sorry, the pH investigation took place on December 2nd on Saturday.
Okay, and the previously scheduled sanitary survey took place December 5th and 6th of 2023, correct?
Yes, that is correct.
Okay, thank you. The executive director, Mr. Brent Westmoreland, was not present for the inspection, was he? For the pH investigation, was he?
Mr. Brent Westmoreland was not present for the investigation. I don't recall. I think probably during that time, I believe since we were a shortage of staff, he was also screening in calls because I believe during that time, we were still going through the whole process of flushing out systems. So we needed people to be answering phone calls during that time. So we separated the work. And at that time, that's when I began to really dive in to start taking over the logistical affairs that were needed in order to start supplying and getting water because there was a shortage. So yes, to answer the question.
So present on that day on behalf of CRRUA were yourself and Mr. Ernest Carranza, who was the lead operator at the time?
Yes, sir.
And at the time of the pH inspection, Mr. Ernest Carranza reported to NMED for the first time that arsenic treatment plant had been bypassed, correct?
I recall discussions regarding it. I wouldn't call it bypass, but if that's what everybody's been using during this hearing, then yes, if you want to use bypass, you can use that, but I don't think that's the correct term.
What? Was it, would you, instead of the word bypass, would you use the word taken offline? It was not operational, correct?
It was operational, however, there was no chemicals being fed, so it was not treating.
Okay, so we'll just call it not, the arsenic treatment plant was not treating at that time, correct?
I do not recall all the specifics because I was very new at that time to the arsenic treatment facilities, and secondly, I did not know the appropriate workflow of arsenic treatment plants. So at that time frame, being that the pH incident took place, I would assume that their operations of turning on that arsenic treatment system plan were either in preparation or it may have already been treating. I don't recall if there was chemical in there. I do recall that there was actually obviously caustic that was actually running through there. So if there was caustic running through there and the pH probe, you had a pH probe incident, I would assume that there would also be ferric also be running through there, but I can't recall during that time where if it was actually offline or if it was running, but there was a malfunction that took place.
Okay, but you just testified a second ago that that you did hear Ernie Carranza talking with NMED for the first time that the treatment plant was not treating at that pH investigation, correct?
You know, like I said, I don't recall the communication that was taking place. If Mr. Carranza did say that, I have no reason to believe, and that statement that was provided, I have no reason to believe it. However, if there was caustic running through there and feeding, that would lead me to believe that that treatment facility was either attempting to be treated, but they quickly turned it off, because during the emergency hearing that took place, Mr. Lopez from Brydell Facility Ops had stated, hey, this is coming from the arsenic treatment facility, go and turn it off so we can stop the escalation of the pH coming from the feed of the caustic. So if Mr. Carranza stated that it had been turned off for previously to being turned on, I believe where the statement may be said is that it was turned on, it was malfunctioned, but prior to it being turned on, it was turned off prior to, and he probably gave a time frame.
Yeah, I think you're being, I don't want to start off on the wrong foot, but I think you're being a little evasive here. You've heard all the testimony that for the first time on December 1st, Mr. Carranza informed, excuse me, NMED that the arsenic treatment plant was taken offline. Yes or no? You said you testified just a second ago that you heard that conversation.
I'd like to object to Mr. Rael characterizing Mr. Crosby's testimony as being evasive. I think he's trying to answer the question to the best of his ability.
Okay, I think he is trying to be precise. I guess that's my impression. And just now, Mr. Rael, you used the date December 1st. I think you meant December 2nd.
Oh, yeah, you're right.
Was December 2nd the first time Mr. Crosby is aware, I guess, based on other people's testimony, that Mr. Carranza informed NMED that the arsenic treatment plant was not, in fact,
Mr.
treating for
Real,
arsenic.
my objective and
Sorry?
Madam Hearing Officer and Mr. Real, I'm sorry if you feel that I'm trying to be evasive. That is not my intent. But now that I know the system much more well than when I knew the system back then, it would be a false statement for me to say that the system was off from the period that the time that Mr. Carranza made his statement to before. And the reason that I'm saying that is because if caustic was feeding through the arsenic treatment facility, that would assume to me that the system was either attempting or it could have actually been on. Now, how long had it been on? I believe that's where you're going, is before that, had it been off for over a year and a half. And I do agree with that statement. As I had stated previously, I agreed with the NMED evaluation that they conducted.
Okay, so you agree that it had been off for over a year and a half.
I agree that it had been,
Objection, that's not what Mr. Crosby's testimony was.
Susan, he just said
Mr.
that. He agreed that it had been off for a year and a half.
All
No.
right, Mr. Real. Thank you, Kim. That's not what he said. I know you're trying to summarize what he said, but I think he gave you the best answer that he could. And again, he is trying to be more precise, and you're trying to get him to be less precise by way of summary. But I believe he has given you the best answer that he could.
Mr. Crosby, did you sign a stipulated settlement agreement that stipulated that the arsenic treatment plants were being bypassed for over a year? Yes or no?
I don't know which agreement you're talking about. May I please have it?
Sure. There's only one stipulated settlement agreement you've signed in this matter, but if you need to be refreshed, I'm glad to refresh you. Do you see the stipulated settlement agreement before you and on your screen? Stipulated partial
I,
final order.
I do see it, but I don't see the date.
Do you see the date now? It says that you signed it on April 4th, 2025. Is that correct?
Okay, I do see the stipulated agreement, but I'm not familiar with everything that is on there. I did sign it, and I do remember signing it. However, my mind is not refreshed in terms of the content that is on there.
Okay. You're intentionally trying to drag this out. This is getting infuriating.
Objection, Mr. Crosby
Susan,
is
object.
just trying to answer the question, and he's trying to answer the questions carefully.
Mhm. The arsenic treatment plants, Mr. Crosby, are required safety precautions or preventative measures to protect CRRUA's consumers from the unauthorized entry of contamination of arsenic in the water supply, correct?
That is correct.
If the arsenic treatment plants are not functioning or have been bypassed, the treatment plants cannot protect the water system and the consumers from the unauthorized entry or contamination of arsenic, correct?
Correct.
The introduction of arsenic at levels which exceed the maximum contaminant level set by the EPA endanger the public water supply, correct?
Correct.
You testified yesterday that you had reviewed the enforcement response plan, correct?
If I understood correctly, you said yesterday, I what?
You testified yesterday that you are familiar with CRRUA's enforcement response plan, correct?
Uh,
Yes, I am. Thank
Objection,
you.
I'm not sure. Are you referring to an enforcement response plan or an emergency response plan? I'm just not clear.
It's called an enforcement response plan, Susan, is what CRRUA's title is. And he testified yesterday he was familiar with it.
Okay, thank you.
So you then were aware that CRRUA knew that, quote, a failure to accurately report noncompliance is considered a significant violation, end quote, and that could carry a significant monetary penalty, correct?
I am aware that there is violations that carry monetary penalties, correct. But I am also aware that monetary penalties in the past from NMED have always been considered for reduction.
Thank you. prior to Mr. Carranza's report on December 2nd about the arsenic treatment systems being bypassed, no one from CRRUA had reported to NMED's Drinking Water Bureau that the arsenic treatment plants were offline, correct?
Once again, I was not in charge of the operations. So if nobody was informed, I was not aware of that knowledge. My understanding is that Mr. Westmoreland, being responsible for the operational control of the water utility, should have or would have been notified. However, I did not ask them that.
To the best of your knowledge, Mr. Crosby, was that the first time that anybody at NMED was informed?
To the best of my knowledge, yes.
Thank you.
This is the court reporter. Is everybody frozen or is it me?
No, I'm not frozen. I do see Ms. Carey going in and out, and I'm wondering, Ms. Carey, if you would like to leave your camera off in order to assure that you have sound, that would be fine.
Oh, no, I'm just, I don't know, Madam Hearing Officer, if you heard, but I have no internet this morning, so I'm using my phone and I'm trying to plug my phone in. So I'm turning the camera off, but I'm hearing everything loud
Okay,
and
good.
clear. So if I'm turning it off, it's because I'm trying to plug something in or moving around, and I don't want to distract people. So I apologize for that.
Okay, thank you so much.
Sorry, it's just that.
Anyone else?
Yeah, when it goes pause from a court reporter's in, I kind of worry. And they're
Okay.
waving at us for some reason.
Mr. Rayal and Ms. Nixon?
We can't hear you.
We can't hear you.
Mr. Trujillo, this is Luis. It looks like you are unmuted. If you can say something. Oh, I can't hear you unless it's maybe you have it connected to headphones or something. You have AirPods, maybe.
Madam Hearing Officer, I'm not recording this or taking this down.
Thank you very much, Kim.
I figured this is just a internet glitch.
I think you're right.
And I don't know
look-
if my office is in downtown Albuquerque, and if I'm wondering if there are internet issues through the downtown area. I'm not sure where their offices are, but I'm wondering about that.
Looks like they're either moving offices or coming back on with a new connection. We'll wait a few minutes. In fact, I think I might get some more coffee. Be right back.
Same here.
Mr. Trujillo, do you have access to the little caret drop down next to the mute button? You might be able to click that and see what your microphone is, what's what's selected to use the microphone there.
Can you hear me now?
Yes, sir.
Okay.
I can.
I apologize for the the delay there. We're having technical difficulties. So, Mr. Crosby, back to my line of questioning.
We're back on the record, ma'am? Okay, we'd gone off, Marcus, I'm sorry.
Thank you, Kim. Following the pH level inspection on December 2nd, NMED conducted their pre-scheduled sanitary survey on December 5th and 6th, correct?
Correct.
And Mr. Brent Westmoreland, the executive director, was not present at that sanitary survey, correct?
That is correct.
And you were present for the sanitary survey conducted on December 5th and 6th?
I was present, correct.
Ms. Littleton testified that at the 2023 sanitary survey, you told her at a pre-meeting that just one arsenic treatment plant was offline. Is that correct?
I do not recall.
Later,
If I did tell her that, that was to the best of my knowledge at the time.
but later, Mr. Carranza informed her during the course of the sanitary survey that it was all of the arsenic treatment plants that had been taken offline. Is that correct?
Once again, yes, that is correct. However, the information I gave to Ms. Brandy Littleton, that was the information and knowledge that I had at the time, given the date that you specified early on.
Ms. Littleton also testified that you stated at that pre-meeting that the arsenic treatment plant had only been offline for about a month or so. Why would you tell her that?
Looking at it from the perspective right now, as I had stated in my statement earlier to you, being that caustic was being fed through the system, it was my understanding that that system was already starting to be online. You have to remember the course of history that has taken place is that I testified that Mr. Westmoreland has stated to the board that they were purchasing parts and some of them were already going online while others were about to be going online. So I was going based off of the information that the executive director had been providing, and being that there was caustic being fed through that system, it was my understanding that that system was being online, not understanding at that time the complexities of all the situation, but understanding now there's caustic being fed to there should also be ferric being fed to there, because if you're treating for pH, you're going to have to start treating for arsenic. So that system would technically be considered online, however, had to be turned off at that time. So technically that system was online. And if we go over to the Santa Teresa community plant, same thing. I believe it was online. And what Mr. Eric Lopez had stated was that he immediately told he immediately told Mr. Westmoreland, go shut the arsenic treatment systems off. I don't recall how many were on at that time. So that's why I gave her the best information that I had at the time.
Testified yesterday that you knew for at least 5 months of meetings that the arsenic treatment systems were offline.
Objection, I believe he's mischaracterizing his testimony from yesterday.
And I don't remember that he said it that way. Would you ask him if he agrees that he said it, please?
Mr. Crosby, you testified yesterday that you were present for at least 4 or 5 public meetings during which Mr. Brent Westmoreland informed the board that the arsenic treatment plants were offline. Is that correct?
That is correct.
Thank you. So you knew then at that time that you talked to Ms. Littleton and informed her that they had only been offline for a month, that they had actually been offline for 4 or 5 months, correct?
Objection. Again, I think the testimony is being mischaracterized.
Susan, he just said correct when I asked him the question.
Madam Secretary, Madam Hearing Officer, I believe that Marcus is asking me the same question, just in a different format. It is beginning to confuse me.
All right, so Mr. Rael, what I keep hearing is, again, you're using words like offline or bypass, and Mr. Crosby continues to draw a distinction between the arsenic treatment unit actually treating for arsenic versus releasing caustics. And he keeps going over and over that distinction, and I think
don't know
that's why
why
he
he's-
can't agree with you.
I don't know why he's going over that distinction. I'm not asking him about caustics. I'm asking him about the arsenic treatment plant being taken offline. And he just acknowledged that he knew from public meetings that the arsenic treatment plants have been taken offline for 5 months. So my question, Mr. Crosby, is if you testified yesterday, and as you just agreed now, that you knew for 5 months that the arsenic treatment plants were offline, why did you tell Miss Littleton that it had only been for a month?
Objection to the characterization of the testimony.
He
That's
did
exactly what
just
he said.
agree a few minutes ago with Mr. Rael's recitation of his statements from yesterday. Mr. Crosby, can you answer, please?
I can answer that question. Can you please restate the question, Marcus?
You testified yesterday and today that you knew for 5 months from public meetings that the arsenic treatment systems were offline. So why then would you tell Miss Littleton that they had only been offline for 1 month when you testified that you'd known for at least 5 months from those public meetings?
I'm going to have to do my best to explain, and I believe I've explained it, but I believe because of the technicality of the situation, I don't think you're gravitating toward where I'm trying to explain myself.
I don't want to hear about caustic or anything like that because I'm not asking about caustic.
That's an important distinction to the arsenic treatment facility. You just stated right now that you don't want to hear about that distinction, but the truth is, if caustic is feeding to the arsenic treating system, that means that system is online and it's treating. Now, are the other chemicals treating? I don't recall the knowledge.
Was it treating for arsenic, Mr. Crosby?
At what period? And in order for me to give you the answer that you need, right, I have to be able to explain. But if you don't want to hear it and just cut me off, then I can't explain it.
I think you have explained it. You've admitted that you acknowledged that the arsenic treatment plants were offline for over a year, correct?
Yes, but you're talking in two different periods of segments, from 2 years ago to what I understand now, and that is a huge distinction that you're not.
Asking what you understand
Then
right
I
now.
cannot
I'm
answer
asking
your
what you-
question.
I'm asking what you understood on December 2nd, 2023 and December 5th and 6th, 2023.
On December 2nd, yes, the systems, from my understanding, had been turned off. However, looking at that now, that is not a true statement.
Okay, I don't care about now. I'm
Well,
asking you.
maybe you don't care, but I do, because that is a technical matter.
Mr.
Gentlemen.
Crosby, yeah, let's not argue with Mr. Rael in responding to a question.
That's right. So, Mr. Crosby, I understand the emotions around this, but I need to caution you and Mr. Rael again not to talk over one another. And Mr. Rael, I'm just not sure how productive this is. We keep going around in circles because of this distinction that Mr. Crosby continues to draw, which may or may not be a helpful distinction for enforcement purposes. I'm not sure between what is offline versus what is treating for arsenic.
Madam Hearing Officer, I'm going to Mr. Crosby's credibility and his knowledge during the sanitary survey and the pH inspection. I'm talking about that time frame. And this goes toward his credibility.
Okay.
And for him to
Uh,
continue to try to explain to me what he now knows as opposed to what he knew during the time frame that I'm asking is not what I just want to know what he knew in December, the very beginning of December, which is December 1st to December 6th of 2023.
Okay,
Madam-
can you
Madam-
answer that,
Madam-
Mr. Crosby?
Madam Hearing Officer, if I may please explain.
Please go ahead.
Marcus is challenging my credibility, but there is a fine line of what was spoken on December 2nd and to what I now know today, which there is a distinction. And so what it does, it makes it appear that I was not telling the truth. And the only way for me to say that is to draw a distinction of what I know now versus what I knew then. But it's a technical matter, and it revolves explanation.
Madam Hearing
Okay.
Officer, at the
Mr.
time,
Real.
Madam Hearing Officer, at the time of the December 5th and 6th sanitary survey, when he spoke with Ms. Littleton, Mr. Crosby knew that the arsenic treatment plants had been offline for quite a period of time. And yet he only told Ms. Littleton that they'd been offline for 1 month. He just admitted to those things. I'm trying to follow up on that line of questioning, if I may.
All right. So, Mr. Crosby, it is certainly within both the realm of possibility and appears to be Mr. Real's conclusion that when you spoke, you misspoke. And I understand that there are different reasons for misspeaking. You may have been mistaken, you may have been lying, whatever it is. If you misspoke between December 1st and December 6th, Mr. Real is allowed to follow up on that. So I'm hoping you'll answer his questions to the best of your knowledge without feeling as though you have to keep building context around it if you misspoke. And your lawyer can certainly follow up with you on redirect if in fact more context needs to be provided. So please go ahead and answer Mr. Real's questions the best you can. Go ahead, Mr. Real.
Is there a dispute, Mr. Crosby, that you told Ms. Littleton that the arsenic treatment plants had only been offline for a month at the December 5th and 6th sanitary survey?
Marcus, to the best of my knowledge, I have misspoken regarding to Ms. Littleton regarding that.
But you did say it, correct?
To the best of my knowledge, that's the information I had at the time. Looking at it now, it is misspoken.
Okay, just please answer the question I'm asking you, Mr. Crosby. We're going to be here.
I did answer the question you asked if it was misspoken. I just said yes.
But you did know that they had been offline longer than 1 month at the time you spoke with Ms. Littleton on December 5th and 6th, correct?
I did know, however, the systems were recently turned off. But yes, I did know that they were longer than 1 month. But when I had spoken to Ms. Littleton, that was the best information that I had at the time.
Ms. Littleton stated that she didn't feel like she could trust you because of this statement and other things, correct?
Objection, I believe she was focusing on the statement in the testimony. I don't recall the other things you're referring to. So if you could refresh the witness's recollection on that testimony.
Mr. Crosby, Mr. Trujillo asked Ms. Littleton directly if she trusted you. Do you recall that?
Yes, I do recall that.
And Ms. Littleton stated, no, I do not. Do you recall that?
Yes, I do recall that.
Ms. Littleton stated that you lied to her face. Do you recall that?
I do recall that.
Thank you. So, Mr. Crosby, why did Mr. Carranza feel compelled to tell Ms. Littleton the truth during the December 5th and 6th sanitary survey, and you did not?
Objection to the form of the question, assuming facts that are in evidence and assuming the truthfulness of one statement and the untruthfulness of the other, if you could restate it in a way that's not inflammatory.
It's a
Yeah,
cross-examination.
Mr. Real, I understand the record does include evidence of Mr. Carranza, so informed ED, and that Mr. Crosby did not, maybe just a little less argumentative, if you will.
Mr. Crosby, Mr. Carranza told Ms. Littleton at the December 5th and 6th sanitary survey that the arsenic treatment plants, all 4 of them, in fact, not just the one, had been offline for over a year. Is that correct?
If that's what Mr. Carranza spoke, that is his statement. Yes, sir.
You heard Ms. Littleton testify to that fact, correct?
I did hear Ms. Littleton testify to that, correct.
So the duration, you also heard Ms. Littleton testify that she had to draw that information out of the 2 of you during the December 5th and 6th meeting by questioning you about the arsenic treatment plants, and that it was not voluntarily told to her, correct?
Once again, Marcus, this event took place in December of 2023, or correct?
Correct.
I did not have all the information. Information was flowing in. And you also have to remember that we were going into the middle of the pH crisis. So all the information that I had at the time was the best information I had at the time. If I had misspoken, the intent was not to lie or to be unfaithful to Ms. Littleton. That's just the best information that I had at the time. And I can clearly understand, being the history that CRRUA has had, where Ms. Littleton can draw that conclusion to say, hey, this is the history that CRRUA has had. Here we go again. So I completely understand, but I did not lie, and I only misspoke based on the information that I had.
Ms. Littleton felt like you lied, correct?
Objection, asking Mr. Crosby for speculative information.
That's not speculative.
He's,
Go ahead.
I'm sorry, Mr. Real. He's
Go ahead.
acknowledged that he heard Ms. Littleton's testimony. Ms. Littleton's testimony is in the record. I'm hoping we can move on.
Mr. Crosby, reporting that the arsenic treatment plants had been bypassed at the time that the bypass occurred is required by the drinking water regulations, correct?
Knowing the information that I know now today, correct.
Yet, again, you did not report the arsenic treatment plants had been bypassed until you were questioned about it during the December 5th and 6th sanitary survey, correct?
Once again, that was not my roles and responsibilities. When I was questioned, I gave the best information that I had based on the statements that were provided in the NMED evaluation.
Thank you. Mr. Crosby, following the 2023 sanitary survey, CRRUA received notice that there were 58 significant deficiencies identified, correct?
Correct.
And the 2023 sanitary survey report required corrective action measures with associated deadlines to attain compliance. Is that correct?
Yes, but associated deadlines have previously been provided extensions if utility systems were able to prove. And my first communication when I was hearing from the local compliance office was that extensions would be granted. And it wasn't until shortly after that extensions were notified that there is no extensions. And then at the end of the 2023 sanitary survey, extensions would would be granted to not have a violation, and it would stay as a deficiency. Historically, if you do not finish
I didn't ask you about any of that, Mr. Crosby. Just please answer the question I'm asking you. Did the 2023 sanitary survey report have corrected action measures, and were there associated deadlines for you to implement those corrective measures? Yes or no?
Yes, but the deadlines were not realistic timeframes for a utility of our size and capacity.
Mr. Crosby, please answer the questions as they're posed again. I heard a lot of context from you yesterday when you were being examined by your own counsel, and to the extent your own counsel wants to help you provide more context, they'll do that on redirect. Please answer Mr. Rail's questions without all the running on, please.
Yes, ma'am.
Mr. Crosby, CRRUA received multiple notices of violation from NMED for failure to implement the required corrective action measures within the prescribed timelines, correct?
Correct.
CRRUA later received another notice of violation in April of 2024 for continued exceedance of the running annual average in excess of the maximum contaminant level at the industrial treatment park plant. Is that correct?
The RAA is correct, but
Thank you. Between those two notices of violation, CRRUA received NMED's amended administrative compliance order and assessment of civil penalty on March 1st, 2024, correct?
I would trust your date of March 2020, but there have been a lot of documents that I'm not recalling right away, but I would take your word for it.
Thank you. Shortly after that administrative compliance order was issued, you testified yesterday that you were promoted to the executive director position instead of being interim executive director, you were promoted to, I guess, just executive director. Is that correct?
Objection, can you give specific dates to help Mr. Crosby put this in context? That would be helpful in asking your question.
You gave him, he testified of those dates yesterday, but sure, Susan. Mr. Crosby, what date were you appointed as interim or acting executive director?
I was appointed as acting executive or executive director in December or January, sometime around that time frame, December of 2023 or January 2024, and appointed executive director around May of 2024.
Yesterday, Ms. Carey refreshed your memory that you were appointed acting or interim executive director on December 8th, 2023. Do you recall that?
Yes, sir.
Thank you. And then you were appointed executive director, you just stated in May of 2024, correct?
Correct.
On June 24th, 2024, CRRUA issued a notice to its customers that a rate increase adopted in 2019 was becoming effective on July 1st, 2024, correct?
You can repeat.
On June 24th, 2024, CRRUA issued a notice to its customers that a rate increase that had been approved in 2019 was becoming effective July 1st of 2024, correct?
Correct.
In that notice, you stated that the purpose of the rate increase was for the benefit of customers, including, quote, keeping arsenic levels within the federal limit of 10 parts per billion, end quote. Is that correct?
That is correct.
Now, the administrative compliance order we just discussed required that CRRUA deliver drinking water with concentrations of arsenic below the MCL of 10 parts per billion at the industrial park treatment plant. Is that correct?
That is
Miss-
correct.
Following the administrative compliance order, it's my understanding that CRRUA implemented a voluntary or special sample schedule to monitor arsenic levels at 4 of the 5 of its arsenic treatment plants. Is that correct?
Did you just say 4 out of 5?
Yes.
There's only 4, not 5.
Okay. So,
Yeah, 4. Yes.
okay. So you did implement a voluntary or special sample schedule to monitor arsenic levels at all 4 of your arsenic treatment plants, correct?
Yes, sir.
On April 4th, 2024, I just showed you an exhibit that was the stipulated partial final order. Do you recall that?
Is that the second amendment?
No, the stipulated partial final order where I showed you the date and your signature on
Yes, sir.
April 4th. Okay. In that stipulated partial final order, you asserted that the arsenic levels at the industrial park treatment plant were below 10 parts per billion, correct?
I'm getting confused on there. Where I stated that they were below 10 parts per billion.
It would be helpful if you could show the document that you're referring to again.
I'm gonna pull up NMED's exhibit 10 again, which is the stipulated partial final order.
I did state in April that the arsenic treatment plants were below 10 parts per billion because I was not going off of a statement from the RAA. The RAA was not the MCL of 10 parts per billion. But the reason I had to state that is to provide transparency to the public. Yes, the RAA, this is how it functions. However, the water that is currently going through the distribution system, the results that were coming in at that time that I can recall were below 10 parts per billion, but that was not including the RAA. That was including the samples that we had been receiving.
Yeah, that's not what I asked though. I'm asking you if you stated in this stipulated partial final order that the arsenic levels at the industrial park treatment plant were below 10 parts per billion.
Objection. I believe the document speaks for itself. The stipulation speaks for itself.
I had that same objection yesterday and you were allowed to continue.
Yeah, to the extent you can see that there, Mr. Crosby, please answer the question.
Are you looking at letter E where it's stating that by March 31st, 2025, that CRRUA must have an RAA for the arsenic below the MCL of 10 parts per milligram per liter?
I'm talking about letter D, please. Read letter D.
Okay, by March 31st of 2024, provide drinking water with concentrations of arsenics below the MCL of 10 milligrams per liter at the industrial treatment plant. I do read that, but that is not including the RAA. It's just stating that we must have the MCL below 10.
Right, that's correct. It's not including the RAA. It's just stating that it must be below 10, correct?
Yes, sir.
Regardless of what the RAA says. So on that document was signed again, as you just agreed, on April 4th, 2024. On April 24th, 2025, during this enforcement action, samples of water distributed from the industrial park treatment plant were gathered by a laboratory hired by CRRUA, correct?
That is correct.
And a report was generated regarding those samples on April 30th, 2025. Is that correct?
That is correct.
Even though the report was generated on April 30th, 2025, the results were not published to CRRUA's consumers or NMED or the general public until May 9th, 2025. Is that correct?
What was the first date that you stated?
Even though the report was generated on April 30th, 2025, which you just agreed to, the results were not published to CRRUA's consumers, the general public, or NMED until May 9th of 2025, correct?
That is correct.
So that's 9 days after the report confirming the arsenic exceedance was generated, right?
That is correct.
Now, the administrative compliance order required CRRUA to contact NMED's enforcement coordinator or its general counsel for purposes of settlement or in relation to the ACO, correct?
Yes, that is correct. It goes against the ACO.
At the time that CRRUA received the results of the April 24th, 2024 sampling, you knew that CRRUA was in discussions with NMED for resolution of the penalties assessed in the ACO, correct?
I was aware that they were going and communicating, but I was not fully engaged.
Right, but you were aware that that was happening, correct?
Yes, I was aware that was happening.
Thank you. However, CRRUA did not report the April 24th, 2025 sampling results to any of the individuals listed in the ACO, did it?
No, it did not.
And in fact, you heard testimony under oath earlier from NMED's Drinking Water Bureau Chief, Joe Martinez, that he learned the information from the press when he was contacted for comment following the May 9th, 2025 press release, correct?
I don't recall his comments.
I assert to you that that was his testimony. Do you have any reason to disbelieve me?
I don't have any reason to disbelieve you.
Thank you. In your May 9th, in CRRUA's May 9th, 2025 press release, you are quoted as stating, quote, "When we received the test results from the Santa Teresa Industrial Arsenic Treatment Facility, we immediately implemented protocols and standard operating procedures. We initiated in partnership with NMED an adjusted treatment that lowered the arsenic level to below the MCL," end quote. Is that correct?
Madam Hearing Officer, I understand the direction that Marcus is going to, but at this point, I feel that this provides explanation, and it's not easy to answer in a correct or not correct statement.
Okay,
Madam
would you
Hearing
repeat
Officer,
this?
Madam Hearing Officer,
Please repeat the question, Mr. Real.
Madam Hearing Officer, it's a cross-examination. I'm just looking for a yes or no answer. And Mr. Crosby is again trying to give me a bunch of explanation with things. I just need a yes or no answer.
But could you repeat the question though?
Sure.
That's
In your May 9th, 2025 press release, Mr. Crosby, you are quoted as stating, and I quote, "When we received the test results for the Santa Teresa Industrial Arsenic Treatment Facility, we immediately implemented protocols and standard operating procedures. We initiated in partnership with NMED an adjusted treatment that lowered the arsenic level to below the MCL," end quote. Is that correct?
That is correct.
According to that statement, you promised the public that CRRUA had immediately implemented protocols and that the arsenic treatment that the arsenic levels at the treatment plant were below the MCL, correct?
That is correct.
However, on May 6, 2025, additional special samples were collected by the laboratory employed by CRRUA to evaluate arsenic levels at its treatment plants, correct?
That is correct.
And the report regarding the May 6 samples was generated on May 12th, 2025, correct?
That is correct. But I need information because there is a time frame between the time that the sample is drawn, let's just say May 1st, I'm giving you an example, and by the time we get back the information. So it'd be helpful for me to have that information because it does take time for the lab to return the reports back to us. It may take 3 days, it may take 5 days. However, when the sample comes out, the sample goes out as of the date that the date that the sample was drawn from the chain of custody, but you have to allow for a couple of days to go by before you can get those reports back.
Yeah, in this case, it was 6 days. May 6th was when the sample was drawn, and May 12th was when you received the results. Correct?
What was the day that it was drawn?
May 6th of 2025, and the report was generated on May 12th, 2025. So 6 days went by, or 5 days.
So if the sample was drawn on May 6th, that sample has to be sent to a laboratory. My question is, how many days before the lab certified the sample? That's the information I don't have right now.
May 12th, 2025 is the date that you received the report back.
Yes, but what you're telling me is that May 6th is the date that we drew the sample?
Yes.
Okay, so my question, in order to answer it, to give you a response.
Mr. Crosby, do you need to see that document that he's referring to?
I would like to see the document because it directly speaks to my time frame when I allowed.
All right, Mr. Crosby, in front of you, I have NMED's exhibit number 27, which is the Eurofins Environment Testing Analytical Report. Generated, do you see right there where the mouse is, generated on May 12th, 2025. Do you see that?
Yeah, so that's the date that we received it, correct?
Yes.
Generated. Okay, when was the sample drawn?
May 6th, 2025.
Okay, May 6, 2025. And when did I release a report to the public?
That wasn't my question. The report
Okay,
to the
good.
public was about
Because-
the previous sample, not
Okay,
about
and
this.
I think that's where I'm getting sorry.
Yeah, can you repeat your initial question, Mr.
Because
Rael?
may I speak, Madam Officer? Oh,
Okay,
Let's
so
have Mr. Rayal repeat his question and then you can answer. Mr. Rayal.
okay.
this report regarding the May 6, 2025 samples was generated on May 12th, 2025, correct?
Yes, sir.
In that report, it is noted that the arsenic levels at the industrial park arsenic treatment plant still measured at 12 parts per billion. Is that correct?
Yes, sir, that's correct.
Furthermore, you're aware that NMED collected a quarterly compliance sample from your arsenic treatment plants on May 7th, 2025, correct?
Correct.
And the results regarding the quarterly sample gathered by NMED from the industrial park arsenic treatment plant on May 7th, 2025 demonstrated an arsenic level of 15 parts per billion, correct?
That is correct.
So then both the May special sample that you took on May 6th and NMED's quarterly sample taken on May 7th were taken after your promise that arsenic levels at the industrial park arsenic treatment plant had been lowered immediately following the April 24th, 2025 sample results, correct?
That is correct, but as I stated in the previous meeting, I did retract my comment and I explained why.
When did you retract your, so you're telling me that you sent out a corrected press release?
No, what I'm trying to tell you is that in yesterday's meeting, I said that that was a mistake because I was going based off of test strips. So I did say that was a mistake.
Thank you, Mr. Crosby. So in answer to my question, the answer was yes, right?
I forgot the question, Marcus.
That both the May special sample you took on May 6th and the NMED quarterly sample taken on May 7th were taken after your promise that arsenic levels at the industrial park arsenic treatment plant had been lowered immediately following the April 24th, 2025 sample results, correct?
That's correct.
Yet neither the May special sample nor the quarterly test results from NMED indicated that the arsenic levels at the industrial treatment plant had been reduced to below the maximum contaminant level, correct?
Correct, but there was no violation.
That's not what I'm asking you. Were they above the maximum contaminant level, Mr. Crosby?
From the single draw sample,
Objection. Can you restate the question, please?
No, it's a pretty simple question, Susan.
I'm sorry, I believe he's already answered it. He acknowledged that they were above the MCL.
Okay, so in fact, Mr. Crosby, the quarterly sample result indicated that the arsenic levels, the NMED quarterly sample result indicated that the arsenic levels at the industrial park arsenic treatment plant had actually increased from 12 parts per billion from your two special samples to 15 parts per billion for their sample, correct?
correct.
So you would agree with me that NMED could not have known about the exceedances identified in the April and May 2025 testing at the time that it issued the original ACO in March of 2024, correct?
Objection. When you say NMED, who are you referring to at NMED?
Everyone, Susan, if the samples were taken in May and the ACO came out in March, nobody at NMED could have known about that because they can't tell the future.
It's an observation about the calendar, right? Okay.
Yes, thank you, Madam Williams. Is that correct, Mr. Crosby?
I lost track of the question, Marcus.
Okay. You would agree with me that when the ACO came out in March, on March 1st of 2024, no one at NMED could have known about the exceedances that happened in April and May of 2025, correct? It was over a year before. So there's no way they could have known.
You're asking me that nobody at NMED could have known. Is that a correct statement?
Yes.
I can't answer for NMED.
Well, let me ask it this way, Mr. Crosby. Could anyone in the world have known that when the ACO came out on March 1st, 2024, over a year before those special samples were taken, could anyone in the world have known that those exceedances identified in April and May in 2025 had happened?
I would tend to agree with that statement. Yes, it's tough. There's so many compliance, even including CRRUA could have known. We go based off of the Safe Water Drinking Act in terms of notifications. That was the ACO was another stipulation that was added.
Right.
Yeah, and objection. I just think there's just been some confusion because that question is, basically asking if anyone a year later can know something that happened a year before. And I think we all know what the answer to that question would be.
Yeah, it doesn't sound like you're confused then, Susan. Nobody could have known, right?
Mr. Rail, at this point, maybe just include that in your argument that nobody has a crystal ball.
Thank
It's
you.
a simple point.
Yep. Mr. Crosby, you talked yesterday, I believe your exact words you testified yesterday were that CRRUA's credibility was shot with NMED and the public. Is that correct?
Current or past?
You were talking about, during your testimony yesterday, you were talking about back when the ACO was issued and afterward, that CRRUA's credibility with the public and NMED was shot, correct?
Yes, over the overall history that has taken place with CRRUA, yes.
Yeah, because of CRRUA's extensive history, the credibility
Yes,
was
sir.
shot.
Yes, sir.
Okay. But the press release on May 9th said you had gotten the arsenic levels below the MCL when that wasn't true, correct?
That was not true, and I stated why.
Yeah.
And that
So
was a
that's-
mistake. People are entitled to make mistakes, just like on NMED side.
Yeah, but that's not how you rebuild trust, right?
No, you rebuild trust by stating the fact that you made a mistake. People do make mistakes. And SOPs were altered, and that is a true statement. We made because of that statement,
But you know,
because that statement is not a lie. And that statement was just misspoken. SOPs were not made. SOPs were altered after that incident because we're in a continuously learning basis.
yeah, I wasn't talking about SOPs, but
It's on the statement.
you never corrected your incorrect press release. You just testified that you never corrected your incorrect press release, correct?
I never corrected it. No, sir.
So that's also not a way to rebuild trust.
Looking at it hindsight, yes, that is not a correct way to rebuild trust. However, there was no violation broken.
Mr. Al, would this be a good time for a break?
Yes, ma'am, we've been going an hour and a half. If you'd like to take a 5-minute break, that's fine.
All right, let's take 10 minutes if we could.
Okay.
Actually, 13 minutes, come back at 9:45.
I have 13 minutes. Okay, thank you.
reporters here.
Thank you, Kim. All right, it appears we have just 45 minutes longer together this morning. So, Mr. Real, do you have other areas of questioning for Mr. Crosby?
I do, Madam Hearing Officer, thank you. Mr. Crosby, yesterday CRRUA provided a rebuttal exhibit. It was CRRUA's rebuttal exhibit number 5, which was a screenshot of your email. Do you recall testifying about that?
Yes, I do recall testifying about it.
And you were using that exhibit to try and prove that you had reached out to Ms. Littleton about a training and that she declined to attend that training, correct?
That was in my email communication thread, correct?
So let me ask you a question. Did you ever have an actual conversation with Ms. Littleton about that workshop?
No, I did not have a conversation, strictly through communication of email back and forth, and the email was just declined. She didn't write or respond back. It was just a decline to the invite.
It was just a calendar invitation, correct?
A calendar invitation was sent, correct?
So again, you never had an actual conversation with her by email or telephone or in person, correct?
I did have communication with her, but
About
not
specifically about the workshop.
no.
Thank you. So do you know why she declined?
I don't know why she declined.
So she could have been busy or something that day, correct?
Objection, asking Mr. Crosby to speculate as to what Ms. Littleton was doing on that day.
Sustained.
All right, point is you don't know why she declined.
Same,
Correct.
same.
Mr. Crosby, yesterday you and Miss Carey went through exhibits, CRRUA's exhibits 21 through 23, which were spreadsheets that identified CRRUA's budget and costs incurred by CRRUA, et cetera. Do you recall that?
To correct a statement, it's cost and planning, also other phase developments. Want to just make sure that was clear.
Thank you. I appreciate the clarification. Those costs, some of those costs represent just routine maintenance and operation costs, correct?
Some of those costs, yes, however, they're severe because due to lack of infrastructure maintenance that has been over the years of ignored maintenance. But the majority of them are for significant capital improvements.
So that's a great point. It was ignored maintenance. So shouldn't CRRUA have planned for those costs to have been incurred for maintenance and operation of its systems well beforehand?
If you can repeat the question regarding?
You just stated that those costs were were for routine maintenance, but it was delayed routine maintenance and they were so high because it had been put off for so long. Is that correct?
From the 2023 sanitary survey, some of the items that we incurred were due to routine maintenance. Nonetheless, they were in the 2023 sanitary survey, but they also reflect they should have been done due routine maintenance.
Yes. So shouldn't CRRUA have planned for the costs incurred for routine maintenance and operation of its systems in advance? Shouldn't that have been a normal part and course of your operations?
That should be, but I was not responsible for the previous year's operations.
Yeah, I wasn't implying that you were. I was just saying as part of a good operation and maintenance of a system, you should plan ahead to maintain your system, correct?
That is correct.
So you would agree that had CRRUA been a little bit more proactive, a lot of this spending would have been spread out over a course of time instead of, you know, an emergency that you had to spend it all at once in response to the 2023 sanitary survey, correct?
I don't feel comfortable with that question. When you're saying CRRUA, are you saying my administration or the previous administration? Or are you lumping everything together?
I'm saying any administration, but I guess I'm referring to prior administrations. Had they done their job, planned for and done the routine maintenance and for operations, then a lot of the 58 deficiencies identified in the 2023 sanitary survey, what, as you just said, would have probably not been necessary had that routine maintenance been planned for and done ahead of time, correct?
Objection. I think there needs to be a little more foundation provided to Mr. Crosby about, you say many of these costs were X, and, perhaps if you could, ask him for specific examples, that would be helpful.
It
Madam
is
Hearing
a
Officer.
general question, Mr. Real.
Yeah, and it's meant to be a general question, Madam Hearing Officer. I mean, do you want me to go into more specifics?
No, again, I'm mindful, now we have 38 minutes together. Do you have an estimate of the remainder of your cross-examination?
I probably 15 to 20 minutes, but like Miss Carey yesterday, I could go over by an hour and a half or so and not know it.
Well, I'm going to have to stop you then with some of these questions because they are not particularly productive, and they're the kind of things that even without drawing it from Ms. Crosby's lips, you can include in an argument as not really being within the realm of dispute. So, Mr. Crosby, perhaps Mr. Real, if your question could just be stated more plainly, if prior administrations had not deferred maintenance, his own administration would not be faced with catching up, right? And all the costs associated with catching up. How about that?
That's a great way to put it, Madam Hearing Officer. Can you answer that question, Mr. Crosby?
That is correct.
So you've testified about the funding that CRRUA is seeking in order to address all of these deficiencies, correct? You testified extensively yesterday about all the grants you're seeking and the different sources from which you're seeking funding.
To address, yes, correct, to address the situations.
And that funding wasn't sought until at least fiscal year 2025, correct? When you took over?
No, there was already funding prior to that I was working on when I arrived.
That had mostly to do with wastewater though, right?
Incorrect. Drinking water SRF was for the arsenic treating facility at the port of entry, a $5 million loan.
But that was in relation to the 2016 ACO to construct that facility, right?
Yes, but I was processing that in 2023.
Right, because it had not yet been completed, correct?
It had not yet been completed. There was other, I don't want to get into details, but I know other grants that I was working with.
Yeah, I heard
Dealing with water.
Considering that the county voted to dissolve your entity after all these efforts that you described yesterday, don't you think that maybe you coming on and doing all this work is just a little too late?
Objection, speculation.
Yeah, would you rephrase that, please, Mr. Real?
Mr. Crosby, do you think that all of your efforts, which you testified about yesterday, and which I applaud you for, are a little too late considering that the county voted to dissolve the entity?
No, I disagree with that comment.
Why is that?
It's going to take a lengthy explanation.
Yeah, I don't want, that's fine. Let me talk to you for a second about the CRRUA's rebuttal exhibit number 4, which was the email string that you provided between yourself, Mr. Lopez, and Mr. Antonio Romero. Do you recall that exhibit?
Yes, sir.
Okay. At the time that Mr. Romero sent this email, this email string took place on Thursday, May 8th of 2025. Do you recall that?
Yes, sir.
So at the time that Mr. Romero sent this email, he didn't have the results, and neither did you, of the May 6th and 7th voluntary test and the NMED compliance sample, correct?
Correct.
And is Deputy Secretary Roderick copied on this email?
Was he supposed to be copied?
You used it to talk about the fact that Deputy Secretary Roderick should have known about all of the efforts you were undertaking. I'm asking if he was copied on the email.
No, what I stated was that it's hard for Mr. Roddick to know everything that's going on with all of the operations. However, I was assured through my local compliance officer that everything that is reported has to be spoken to his higher ups. Not only that, speaking to Martin Todes, he also notified me because of CRRUA situation, everything that happens in CRRUA has to be reported to Santa Fe.
You don't know to who, correct?
I don't know to.
Okay, and so just to answer my question, was Deputy Secretary Roderick copied on this email string? Yes or no?
No.
In fact, this email with Mr. Romero, since it was on May 8th, 2025, took place before your May 9th public notice where you promised that the arsenic levels were below the MCL, right?
Correct.
I have another question. You also used this email to show that Mr. Romero stated, and I quote, "I commend you all on the great effort, work, and resiliency you're all doing," end quote. You recall that?
Yes.
Did you inform your own board about the AWOP training and all these accolades that you were receiving after you got this email and after you enrolled and volunteered for the AWOP training?
The board is aware because they attended the trainings.
Then why did they vote to dissolve your organization right after this email?
Objection, really going beyond the scope of direct, and also you're asking for Mr. Crosby to infer what the board was thinking when it voted on the dissolution. And
I'm not asking him to infer. He was at the meeting.
Okay, but what, Mr. Real, what does this have to do with the matters at issue in this hearing?
Well, what it has to do with is that there's been a lot of testimony, Madam Hearing Officer, from CRRUA's side that the April and May 2025 samples are no big deal. They were not a violation. They were not an exceedance. CRRUA was doing great at that point in time. But yet, right immediately after those 3 samples were taken, literally the day after the report came out on May 12th, they voted to dissolve the entity.
Madam
And
Hearing,
so,
I've gone through, I'll object because the fact of the matter is that Mr. Ryle is misrepresenting the vote. The CRRUA board did not vote to dissolve itself. The Doña Ana.
sorry, Doña Ana County voted
This
to dissolve,
Okay,
the entity.
This is
And
a
hold on,
misrepresentation.
hold on. No, I understand. Hold on. Mr. Real, I don't remember this being part of the department's case, that this somehow supported the that the dissolution supported the bad faith enhancement of the penalty. Am I wrong about that?
no, you're not, Madam Hearing Officer. What I'm saying is Mr. Crosby brought it up, and Mr. Trujillo went through great pains to bring it up during his cross-examinations that, and also Ms. Carey brought it up with Mr. Lopez yesterday, that the April and May 2025 exceedances were not a big deal, that they did not violate.
You broke up, Marcus.
That they were not a big deal, that they did not violate the RAA, that they were not exceedances. They went so far as even to say that. And so what I'm trying to point out, Madam Hearing Officer, is that if they were not a big deal, why did the county vote literally the day after those results came out to dissolve the entity?
An objection, I would object to the characterization that all of CRRUA's witnesses were saying that the test results weren't a big deal. They were putting the test results in the context of the fact that they weren't a violation of the drinking water regulations. But you're kind of implying a flippancy to the test results that I don't believe was reflected in the testimony.
All right, and
I
I frankly
disagree
am not
with that.
interested in hearing any more about the dissolution at this point. I understand Mr. Crosby brought it up, but I really am not interested in hearing any more about it, and particularly because the department didn't, it wasn't part of what went into the bad faith enhancement of the penalties. Do you have other areas of questioning, Mr. Rail?
Madam Hearing Officer, I'm not understanding why I'm getting limited in time when CRRUA is not limited at all.
Well, a lot of the questions this morning have what? Not been productive in the way I thought they were going to be productive with Mr. Crosby. And I understand that we have Mr. Crosby's long answers when you were asking fairly simple questions, but we've also heard an awful lot about the calendar and whether May 8th comes before May 9th and May 9th comes before May 12th. And that hasn't been especially helpful to me. So I'm hoping, yes.
Madam Hearing Officer, the bad faith enhancement is based on that new information, those tests, and they went to great lengths to say that those tests didn't mean anything. And what I'm trying to say is they absolutely did, not only to NMED, but clearly to Doña Ana County, since they voted literally the day after those test results to dissolve the entity. So if you're taking notice of that, then that's fine, I can stop.
I mean,
Yes,
maybe you
please
have.
stop.
Yeah, okay.
Ms. Carey, I really
won't.
don't want to hear anymore. Mr. Rail, do you have other areas of questioning for Mr. Crosby that would help with the issues in this second amended compliance order?
Oh, yeah, just a couple. Mr. Crosby, you said yesterday that you could either be reactive or do nothing. Do you recall stating that?
Yes, I do recall stating that.
Wouldn't another alternative be to be proactive?
I get where you're going, and I hear what your statement is. But what my meaning was, if you want to use proactive and get caught in the semantics, yes, you want to be proactive. And I believe all the actions that I explained yesterday speak directly to all the proactive measures, many of which I have not had the time to explain.
Okay. I just have one more question for you, Mr. Crosby. Where do you reside?
City of Sunland Park, 133 Meadow Vista, Unit B.
Are you served by CRRUA's water system?
Yes, sir.
I have no further questions for this witness, Madam Hearing Officer.
Thank you, Mr. Real. Ms. Carey, do you have any redirect?
I have several redirect questions, but which I think will take 10 minutes, but since we're all in different locations, if I could have 3 or 4 minutes to talk to my co-counsel, to consult with him on that issue, or a 5-minute
All right.
break.
Okay,
Thank you.
so 4 minutes puts us at 10:10. Let's come back at 10:10, Mr. Real.
She's not going to be consulting with Mr. Crosby, correct?
No, I'm
No,
talking to my co-counsel.
Yes, I would just
Okay.
ask that we verify that somehow, since we're all in
Yes.
different locations.
Yeah.
Mr. Stay on camera.
All righty. 10:10.
I'll stay here with my microphone on.
Thank you, Mr. Crosby.
Let's come back from the break, please.
Court reporter's here.
Thank you, Kim. Ms. Carey? Ms. Carey?
We were just on the phone.
Just dropped off, Your Honor. Maybe she's trying to reestablish a connection.
Okay. Participants. Well, there she is.
Sorry, I had accidentally disconnected. Sorry to keep people waiting.
Please go ahead.
Okay, thank you. Mr. Crosby?
Yes, ma'am.
Just several questions here. So you answered questions from Mr. Rael this morning regarding your conversation with Miss Littleton during the sanitary survey, and then information you had learned at board meetings. Is that correct?
That is correct.
And you had testified that you had attended, I believe, 4 or 5 board meetings where you heard testimony from, or you heard information conveyed by Mr. Westmoreland concerning the arsenic treatment systems, correct?
That's correct.
And you learned information that parts were being ordered for the treatment plants, correct?
Correct.
And then, but when you met with Miss Littleton, I believe your testimony was that, or at least Mr. Rael is characterizing your testimony as being that you believe the treatment plant had been offline for a month. Is that correct?
That's correct.
And so, do you believe these two statements are inconsistent?
I believe they're inconsistent just because one time frame was when I was getting the understanding from Mr. Westmoreland's briefing to the board in terms of the process of them going up sequentially, not knowing the time frame. When Ms. Littleton came, it was a different information that I was aware of. Part of the information that I was barely gravitating to from Mr. Carranza and from Ms. Littleton, so I gave the best information that I had known. But as if it may be misconstrued or misspoken, I would leave it as that.
And did you have any intent to deceive or lie to Miss Littleton?
No, I had no intent or to deceive Miss Littleton. I've been trying my best ever since I've gotten there to have open communication and dialogue with the local compliance office on many matters.
Okay, thank you. And I'd like to go back and just ask several questions on the May 9th press release. So, so the press release was released on May 9th, is that correct?
Yes,
And was the press release talking about the results? Um, was it discussing addressing issues that occurred based on the April 23rd voluntary test that CRRUA conducted?
yes, that was it in regards to the control sample that was used for operators.
Okay, and so do you need to see the press release?
Yes.
Or okay,
No, I remember the press release.
okay. And so generally, what were you conveying? Um, well, let
The
me
me-
back up. Let me back up. I'm sorry. And so at the time of the press release, you had the results of the April 23rd test. Is that correct?
yes,
And that result was and it showed 12 parts per billion at the industrial park, correct?
correct.
And would you agree that you received those test results on or about May 1st?
Yes, approximately yes.
And then between May 1st and the time of the press release, was any field testing conducted?
There was field testing conducted by operational staff, and that's
And
where I draw my
and what were the results of those field tests?
the field tests. To my recollection, were below the 10 parts per billion. And however, I stated that that was a mistake to rely on field test trips instead of getting the results to come back.
Oh, so let me go back to that for a moment. When you drafted or when you released the press release, were you relying on information from the field test to convey the information that you conveyed in that press release?
Yes, because the information that I had received was that they increased the dosage of arsenic. I'm sorry, they increased the dosage of ferric to treat for the arsenic, and that the adjustments had been made. In addition to that, SOPs were updated.
And at the time the press release was released, you did not have results of your May 6th test. Is that correct?
No, I did not yet have the results from the May 6 test.
And would you agree with my statement that those test release or results were received on May 12th?
Yes, they were received on May 12th.
And at the time you made your press release, were you aware of the results of the compliance sample taken by NMED on May 7th?
At the time of the release, I was not aware because it was prior to the date that I released it. I released it on May 9th. Those results came back on May 12th. They're
No,
two separate items.
what about the results of the NMED testing that they took on May 7th? Do you know when those
No,
results were posted?
I don't know when those results were posted, but when I made the release, it was based off of the sample, the operational sample, not out of the samples made from the quarterly samples from NMED.
And so when you characterize that you made a mistake that you've apologized for, what was that mistake in the press release?
The mistake on the press release was to go based off of field strip testing and adjustments made by operational staff, which
And
were below the MCL based off of the field test strips.
why was it a mistake to base it on the field test?
It was a mistake to base it because when you make these decisions, you should be going based off of a certified result from a lab. A mistake I have made and a mistake that I've learned.
And going forward, would you not make that same mistake?
Yes, as I said, it's hard to build trust. Any little slip can be shown as being misleading or lying.
And with regards to the email from Mr. Romero on May 8th. Have you had any conversations with Mr. Romero since that email?
Yes, I have.
And what were the substance of those conversations?
The substance of the conversations were that what CRRUA is doing with enrolling in the AWOP program is that we are taking all the corrective measures that are needed. And our communication and discussion was regarding how NMED was responding, because we did not break any violation. The fear was going to be that other utilities could see this as a way to not want to be volunteering, because it's not needed for us to volunteer those results, nor for other utilities when we're taking operational control samples. However, it's going to the extent of how much we're willing to participate. All utility systems across America and in New Mexico do have hiccups. The purpose and the intent of that AWOP program did what it was designed to do, is to catch a problem before it gets out of hand. And that's what the communication, and that's what Mr. Romero was speaking to about how CRRUA was advancing in terms of what we were trying to do. We're achieving our objectives.
And did you have any conversations with Mr. Romero after the May 6th and May 7th operational and compliance test results were released?
I did have conversations with him regarding the processes that we were taking and what was the steps that we were taking to resolve the situation.
And how would you describe the tenor of those conversations?
You know, the tenor of the conversations is that Antonio's seen many systems. He's seen systems fail. He's seen systems rise up. And the discussions that we have is, and my feeling is, to be able to utilize CRRUA and the mistakes that have been made in our utility and our involvement with the AWOP program. Our communication is to build a blueprint for other utilities as a way to follow when things go wrong, like what wrong with the PH incident. So that is our communication. It's a very collaborative relationship that is just not stopping now. It continues to grow as we continue to find ways to optimize our system.
Okay, thank you. I have no further questions.
Anything further from anyone?
Just thank you, Madam Hearing Officer, for allowing us to continue and finish today.
Thank you.
Thank you so much.
Madam Hearing Officer, this is Adán Trujillo. In regards to the proposed findings of fact and conclusions of law, as well as the closing statements, I know this morning that you mentioned that the 30 days, I can pull up the rule, but my understanding is that 30 days starts upon the delivery of the transcript. Is that correct?
That's correct. That is
Okay,
correct. Under 20.1.5, the hearing clerk will inform you with a document called Notice of Transcript Filing, that in fact the transcript has been filed with him. You will contact the court reporter directly to obtain a copy of that. Ideally, on that notice of transcript filing, Luis, if you would, please make a note of the 30th day following that day, so that we're all on the same page around the day that post-hearing submittals are due. And again, those post-hearing submittals cannot include new evidence. They can include written closing argument, proposed findings of fact, ideally with citations to the place in the record forming the basis for that finding of fact, and proposed conclusions of law with citations to applicable law and regulation. I then have 30 days to draft a report and recommendation to the secretary. I can't remember if the 2 weeks is included in 20.1.5, where you have an opportunity to comment on my report. And then the secretary has 30 days after that to issue a final order. I see Mr. Rael's hand up. Mr. Rael?
Madam Hearing Officer, I was just going to ask if Mr. Lopez can also include Kim's contact information so that we have it to ask her for a copy of the transcript?
Yes, I'll send that out, Mr. Rao.
Thank you.
Thank you. And I see Mr. Crosby's hand up.
Madam Hearing Officer, I just wanted to thank you. I know that this was this is my first time going through this process, and I wanted to thank Marcus and thank our legal team and also everybody involved here. So I appreciate the time, and apologies for any missteps or inappropriate response on my part.
Thank you, Mr. Crosby. Anything further from anyone before we adjourn? No?
No,
All
but
right.
thank you, everyone. Appreciate it.
Thank you, everyone. Have
Thank
a
you.
great
Bye-bye.
rest of the week.
You too. Thank you.
Thank you.